Yeah, just before the pandemic, the COVID-19, I was in Geneva in February.
Yeah.
So we had a beautiful, wonderful time during the
Yeah.
Human Rights Council meetings.
Were you by any chance for the UPR of Turkey?
I think during the UPR, I was not there, but I think it was before that. It
Well,
was,
in any event, the UPR was you know, broadcast on the web. You could have seen it. What bothered me when I went was, how uh, shall we say hypocritical most of the diplomats are when they ask questions about Turkey. The questions they did not ask was more telling than the questions they did ask, and then they accepted without any kind of criticism whatever nonsense the Turkish diplomats gave them. So I didn't think it was a very productive UPR process. I mean, before the Human Rights Committee, when they come before the Human Rights Committee to present a report, the 18 experts of the Human Rights Committee are far more, far tougher, and they don't like to be told lies. So they actually ask again and again. But when are we beginning? It is now 1 minute to 3. And who actually begins it? Do you, Eric? Or is the office in Geneva that actually calls the meeting to order?
I don't know. You are supposed to be the one
I
giving
am the
us the floor.
moderator, but I was not giving any instructions
Yeah.
other than to moderate and actually make some comments on what you, Eric, say and what Roland says, so on and so forth, and make a small introduction. I don't want to be too long. I just finished with another panel, which was supposed to last an hour and a half, and it lasted 2 hours and a half.
Oh, yeah.
Happily, I was the first speaker, and I tried to keep myself to 10 minutes, but nobody else did. So it just went completely over. And so I'm a bit on the tired side, moving from Kashmir to Turkey. And, and also, in a way, on Human Rights Day, you would think you would celebrate all the achievements of human rights over the last 72 years now. But of course, there's something to be thankful that we do have the standard setting, that we do have the norms, that we do have the mechanisms, that we do have the treaty bodies, that we do have the special procedures of the Human Rights Council. But the problem being the implementation gap, and it remains. And the problem being the uh, unfortunate attitude of many governments, not only my government, the United States of America. I don't think that there will be miracles when Joe Biden becomes president. It will not be as unpredictable. It will not be as, shall we say, um, irritating as under Donald Trump. But I don't think that the parameters of the United States foreign policy are going to be changing very much. And the attitude of the United States vis-a-vis the Human Rights Council and vis-a-vis human rights in general is not going to be very much better. There will be lip service to human rights, but the weaponization of human rights to target some countries and not others, that is likely to continue. The way that the U.S. administration just simply picks and chooses whom it's going to attack and engages in, shall we say, a vulgar xenophobia and Russophobia, etc., while it deals with Saudi Arabia and deals with the United Arab Emirates, and it deals with all of these countries that violate fundamental human rights every single day. And that brings us also to Turkey and the fact that Turkey is a state party to so many of the United Nations human rights treaties, and not only a state party to the Convention Against Torture and to the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights and the Convention on the Elimination of Racial Discrimination. But Turkey actually has exposed itself by ratifying the optional protocol to the Covenant on Civil and Political Rights, and by accepting also the Article 22 procedure of CAT, that is the petitions procedure. So that you would think that Turkey would be highly vulnerable to a flood of cases, to a flood of complaints from petitioners who actually under Article 6, right to life, Article 7, torture, Article 9, arbitrary detention, Article 10, conditions of detention, Article 14, denial of fair trial proceedings, Article 19, freedom of expression, Article 21, freedom of peaceful assembly, Article 22, freedom of association. And even though there are cases before the Human Rights Committee, as you all know, the views, the decisions on the merits of the Human Rights Committee are not binding. Of course, a country that voluntarily ratifies a petitions procedure, you would tend to think if it does so in good faith, because it intends to pay attention to the conclusions of an expert body. That, of course, is the theory. The practice is that Turkey ignores the decisions of the Human Rights Committee. And not only, when I think in terms of the European Court of Human Rights, whose judgments are legally binding, even there, where the European Court of Human Rights has found that Turkey has violated provisions of the European Convention, has violated the protocols, etc., etc., you don't get an immediate positive reaction from Turkey. So we have here, in the case of Turkey, a very serious problem of implementation of decisions. But as far as I'm concerned, and I'd like to learn from you, and I'd like to hear the experience of Eric Sotas and the experience of Mehmet Kilic, etc. How is it possible that the mainstream media makes so little out of the amazing situation prevailing in Turkey, where, I don't know, having been Secretary of the Human Rights Committee, having been the chief of the Petitions Department, having worked as an independent expert for the United Nations, how is it possible that Turkey gets away with it, and that the mainstream media doesn't make it a major issue, the number of judges who have been dismissed, who have been prosecuted, detained, the number of journalists, the number of teachers, the number of professors that have been dismissed and jailed. It is a situation that for, shall we say, what you would consider a civilized country is almost inconceivable. And then the European Union, that so happily imposes sanctions on so many countries, whether it be Belarus or Russia or Syria or what have you, They don't want to impose sanctions on Turkey. They want to continue doing business with Turkey. It is really a major um, disappointment when the European Union, that is supposedly based on values and that doesn't cease to invoke human rights, how they tolerate the situation in Turkey. Excuse me for a second. Hello.
Hello. Actually, I wanted to make an introduction at first, but I didn't want to just cut the Alfred Zayas speech. So here today we have as moderator Alfred de Zayas, as you all know, as a former UN expert on international order. And we have three panelists, Eric Sotas, Mehmet Kılıç, and Setonji Roland. Eric Sotas, as you know, he is the former Secretary General of the World Organization Against Torture, OMCT, and Mehmet Kılıç as the president of the Journalists and Writers Foundation from New York, and Mr. Setonji Roland Adjovi as a former UN independent expert of the UN Working Group on Arbitrary Detention. Today, we will have the introduction of Alfred de Zayas at first, as he's our moderator. And then we will have the comments of Eric Sotas. Then Mehmet Kılıç will intervene. And then lastly, Mr. Setonji Roland will make his comments. Then we will have the question from our moderator to the panelists. At the end, we will ask your questions to the panelists for 25 minutes. So you can start asking your questions from now on, so that we can, at the end, we will all collect them and then we will pose them to the speakers. So don't hesitate to ask questions. Thank you very much. Mr. Alfred de Zayas, the floor is yours.
Thanks again. And you've done a good introduction for Eric and Mehmet and everybody. Now, I don't know whether what I said prior to your introductions was already in the webinar, and those who clicked in already heard it. So I don't wish to repeat everything that I said.
Yeah, you can go.
Just to come back to the fact that we do have a vast series of mechanisms, and Turkey actually has recognized the competence of the Human Rights Committee to examine individual petitions, has recognized the competence of the Committee Against Torture to receive petitions, has given invitations to a considerable number of special procedures mandate holders. I mean, if I look at the list, and everybody can check it in the Office of the High Commissioner for Human Rights website, you will see how many visits, and we will learn more, no doubt, from Roland, the visit of the Working Group on Disappearances. They had a visit already in 1998. And the Special Rapporteur on Torture was there in 98, the Special Rapporteur on Freedom of Religion in 99. Now let's go a bit closer to our dates and closer to the attempted coup in 2016. You have the report of the Working Group on Disappearances went there actually before the attempted coup. That was in March of 16. You have the report of the Rapporteur on Freedom of Expression in 2016 in November, the Special Rapporteur on Torture in November of 2016. So there have been, since that, there have been a number of requests which have not been complied with. Human Rights and Counterterrorism requested, but has not taken place. Human rights defenders requested, cultural rights requested, freedom of assembly requested, they got a reminder, and Special Rapporteur on Housing was supposed to hold a visit in 2020, indicates here it was postponed, and working group on arbitrary detention in principle accepted that they conduct a visit in November 2020. There are other mechanisms. For instance, the inquiry procedure under Article 20 of the Convention Against Torture. These things can still be exhausted, can still be at least attempted to engage, because you cannot do anything without the cooperation of the state. But if you have no cooperation from the mainstream media, if the mainstream media does not make a fuss about this totally abnormal situation of obtaining in Turkey, and the activities of Turkey in kidnapping people, it is almost unbelievable that something like that can occur in the 21st century, that a country like Turkey sends its agents to kidnap, especially suspected Gulen members throughout the world, whether it be Pakistan or Morocco or Latin America. So this is something that just jumps to the eye and actually offends anyone's conscience. Nevertheless, the mainstream media really does not focus on it. And that is one of the issues that maybe some of you may want to address in this webinar. Maybe some of the listeners would like to pose questions in this context. Also, in particular, the persecution of members of the Gulen movement. The Gulen movement has been subject of so much defamation and so much disinformation. You would expect that the mainstream media would try to make an effort to report accurately on the Gulen movement, but they do not. And the fact remains that a lot of people are wary of the Gulen movement, and even though they don't say so, they say, well, maybe they were in fact behind the 2016 attempted coup. So there is, shall we say, limited sympathy in the mainstream media for members of the Gulen movement. Having said that, and having already spoken at the earlier part of this webinar, I will now give the floor, first of all, to Eric Sotas. In principle, you have 10 minutes. In total, I think we're supposed to have an hour and a half for the webinar. So I will try to indicate to you when you have 2 minutes or 1 minute left, and then I'm sure we can come back to you later. Thank you, Eric. The floor is yours.
Thank you very much, Alfred. Well, first of all, I would like to thank the organizer for the invitation to attend this and to participate in this webinar on a subject which is very crucial at this moment, which is what are really the efficiency, achievement, or limitation. But for me, the central question is the efficiency of the UN mechanism, both the system of treaty bodies and the special procedure in relation with Turkey. On the question of Turkey itself, I think Mehmet and the order probably will come with much more elements. So I will, since we have 10 minutes, and I will try to respect it. And since it's already difficult to address all the complex matter linked to that question, I have decided to focus more on the question to see what are the difference between the two procedures, because I think there is some confusion among I would say among the victims who need to address and they don't know where they have to go. I will try to show what are the purpose of this system and how it works or it doesn't work in some instances. And I will focus on the question of the individual complaints or individual communication, we can say it, particularly because people sometimes have a wrong idea about what exactly it will mean in terms of conclusion of the mechanism and what they can expect from them. If we go back to 1945, when the UN adopted the charter, they codified 3 principles that I think are difficult on the concrete situation to, let's say, harmoniously work together. I mean by that, on one hand, you have the question of the equal sovereignty of state, which has been reinforced with the decolonization, where states are reluctant to accept something coming from outside. And even in countries like Europe and United States in the recent years, there is a tendency to say America or order first in terms also on law. Our law is above. The second point is the human rights system. The human rights system has to be universal and should apply everywhere. And the prohibition to use forces in international relations complete these 3 principles. But when you are facing an authoritarian regime which is not answering to the different type of, let's say, incitation and a different type of warning that the system is addressing, it's becoming problematic to see how we manage to get rid of that. First of all, we have also to remember that, like you have mentioned already, and it's very important, what the Commission has done, and now the Council continue, was from the beginning the standard setting. Now we have a system which I will consider has an importance not only in terms of reference, but is a reference for all the countries, and I would say is a reference for the different procedure. This is the Bill of Human Rights with the 3 pillars, the Declaration and the 2 covenants, the one on economical, social, and cultural rights, and the one on civil and political rights. I insist on that because sometimes people understand that the special rapporteur have less or more influence on one question or other. No, every state has an obligation to enforce those rights, being or not being part of a treaty system. But what the treaty has introduced, and for me it's fundamental, what the treaty has introduced are some mechanisms in order to, I don't like the word because it's not the most correct, but in order to monitor how states are really implementing their promises to respect human rights and to take any type of measures to reinforce them. For that, we have, at the level of the treaty bodies, we have, from my point of view, 5 levels. The first one is the report. States should report. Why insist on that? Because I remember when I was Secretary General, that was a nightmare, to the point that at one moment, the NGO, we decide to write the report for the states, not as a report of the state, but as something we can give to the experts. And what was interesting was that some committees decide to use our messages, our reports, saying since there is no report coming from the states for years, we will use reliable sources. So the report is important, and we have to be very careful when the states stop to present report or accept to have so long delays that it make it a little bit problematic to analyze. The second one is to take part in the meeting where the exchange will take place with the experts, because this exchange is very important, not only in order to understand the report, but to listen the type of criticism that can come or the type of question that are coming from experts, but also, I will come on that later on, from NGOs or from other sources. You have already mentioned that the inquiry possible, for instance, in the Committee Against Torture, but that is very not so much used. I remember the case of Egypt some years ago, where it was impossible to receive information. It was getting worse and worse. And finally, the committee decided on the basis of several reports coming from the NGOs to start an inquiry on its own. But this is not I would say, the most common one. And like you mentioned, we are already surprised by the lack of reaction on Turkey. I doubt that such an initiative will be taken at this moment. The other thing is the question, if it has been, and you have mentioned it, that it has already been done for the torture, for the committee, also on human rights, the possibility for an individual under the jurisdiction of a country to present a complaint, a petition, a communication, following the real word used by the convention, to the committee in order to denounce a violation affecting that person directly and asking the committee to pronounce itself. And finally, in this context, one point I think we have to insist are the protective measures, measures taken to protect and try to stop the things before the irreparable is done. So this is, from my point of view, the elements that we have to take into consideration to see the achievement and the limitation. On achievement, I will say that the examination of the country has very much improved since I've followed the cases. I like to remember that I was the first one to attend a meeting of the Committee Against Torture at the beginning. And at that moment, they didn't even know if they can accept an NGO because there was no space for us, etc. But what was for me very problematic was the way they have to work. You know, the UN has a lack of resources, but that's been always a problem. But the president at that time, he was Voyam, the first president of the committee. Voyam, at the beginning of the session, start with a pile of document that were the report, and he said, okay, you speak French, can you take that country? You speak Spanish, can you take that country? And after distributing, he said, okay, we will see the country, you will be rapporteur on that country, and we will see that tomorrow on the day after. And
hey, 10 minutes, huh? 10 minutes already, but go ahead.
Oh, sorry. In this case, what I mean is there were no possibility really for the experts to prepare the document. They were reading the best, but the day after, when the ambassador was coming, it was impossible for the experts to really ask the accurate question, since things were lacking. So to take it short, we decide with OMCT to prepare this report, alternative report, and that took a certain time to be accepted by the system. But recently, when I went to follow a meeting on Colombia, I realized that now you have two sessions, one with the NGOs and the experts, and the day after or 2 days after, a second meeting with the government. That means at this moment, you have at this level a much stronger possibility to really challenge what is presented. And I don't understand why the press like you is not more present in this type of meeting, because for me, it's important. Now, limitation. There is a confusion very often for the victim. They see the system as a type of fourth instance of appeals, which is not the case. This is not the role of the committee. The committee cannot decide to consider that, to set a sentence aside, or to consider that the last judgment of a country was wrong. You know, what he can say is to say these facts, these cases present violation on this article, like you have mentioned. Having said that, the country is supposed to take measures either at the legal system or even concrete measures, one, to redress if the legal system is not providing adequately the definition or the way that things should be handled, but also it should also consider the other elements, which is reopen investigation, because it means the investigation has probably not been conducted seriously, particularly on torture, identify and sanction perpetrator following the law, and rehabilitate the victim. Most of the states are ignoring this obligation, you know, even when they are, some, when they are condemned, try to pretend that they have done a mistake and that they have maybe not completely respected what was supposed to be done, but rarely we see a state changing completely how, in the sense it is supposed. So if I already reached the 10 minutes, I think I will stop here. Maybe just make a small reflection on the special procedure. You know, for me, the special procedure, the most interesting to understand the mistake about the special procedure is to go back to the 1503 procedure. Yeah. Very often people were considering that was a procedure for individual because you can present cases to them. But no, it was like the older system of the special procedure. I'm making a presentation with a little bit short, but it's done to help the commission to collect information and to continue to work on the situation in the country. What it mean? It means that when the person, victim, or some member of his family, or some NGOs are presenting the case of a victim in the 1503 procedure, it was in order to accumulate cases to prove that there were gross and systematic violation, and that the Commission on Human Rights, at the end of the process, after passing through the subcommission and so on, should put this country at its agenda. The case very famous was the case of Tiananmen, with a big battle to get China on the agenda. But the reaction was that China make a strong pressure, and finally, when it came back when finally China presented its report, a very poor report, to the commission considered it was acceptable and it stopped. What it mean? It mean, and that's my last point, it mean that we have to see these procedures for what they are. On one hand, a system to monitor if countries are really implementing what they are supposed to implement. And here we need much more mediatization to push the country. Secondly, we have also to see that we need to give a better information about the reports of the special rapporteur of the working group on the different subject, disappearances, summary execution, and so on, because at the end of the day, these are the reality that the Commission is supposed to deal with. and from that to go and at the end to have a debate at the General Assembly, even at the Security Council. But the politicization of the system and the lack of sanction directly linked to this mechanism is making that people start to lose confidence in the system. And recently, 3 days ago, sorry, three weeks ago, I was consulted by somebody if really he has to fulfill all these documents if the protection he can expect was so poor. And I think we are at this moment facing this question. The number of special experts.
17 minutes already.
I stop.
Yes.
Sorry.
And we can take from the section questions and answers from the moderator. I will be very short on that, but first, I agree with everything you said. I would just like to footnote one, interim measures of protection. That is something that the victims must systematically demand. If there is irreparable harm, they must demand interim measures of protection. And what's interesting is that the Committee Against Torture and the Human Rights Committee both issue these interim measures of protection, and most of the time the states obey them.
Yep.
The states very frequently disregard the decision on the merits. When the CAT comes out with an opinion or the Human Rights Committee with its views, the states apply them maybe 35% of the time, 40% of the time, and that's it. On the other hand, they do accept an injunction. While the committee is examining a case, they will not expel, they will not extradite, they will not execute someone. Exactly. So that in itself is an advance. Monitoring in itself is a great step forward. We must know what is going on. And the other development is the follow-up procedure. Human Rights Committee has a follow-up rapporteur for views, a follow-up rapporteur for recommendations in the state reporting procedure. Same thing with CAT. That was a tremendous move, started in 1990, and it has actually led to much greater cooperation from states, because a special rapporteur on follow-up actually engages directly with the ambassador here or with the government. And when I was the secretary of the committee and I went with a special rapporteur on follow-up, there was Andreas Mavromatis from Cyprus, and we went together to Jamaica for a week. And we obtained commutation of sentence of all of our cases, and what was more important, a total moratorium on the others. So our cases were moved from death sentence to life imprisonment, and the others were put on hold, on moratorium, which has been respected to this day. But one point, very important, states have actually accepted the competence of these bodies to monitor and the competence to issue recommendations. If they are in good faith, they will implement these recommendations. But it's also for the entire world, for the human rights family. Erga omnes, every country has an interest in the implementation of these views. So it's not an interference in the internal affairs of another state if, say, France says it wants to see the decisions of the Human Rights Committee concerning Turkey implemented. It is not interference. France is a state party to the Covenant on Civil and Political Rights. France is a state party to CAT. Therefore, it has an interest that this treaty be respected by all other states parties there too. Having said that, I would like to give the floor to Mehmet Kilic. And before...
Just before,
yeah.
I want to make just a brief Turkish explanation on what was said by Mr. Erik Sotas,
Yeah.
seeing that we have a huge number of Turkish-speaking followers. I just want to very briefly. Erik Sotas beyefendi az önce şunları anlattı. İnsan haklarını inceleme mekanizmalarında Birleşmiş Milletler önündeki en büyük karşılaştığımız büyük sorun olarak herhangi bir bağlayıcılığı olmayan bir sürecin olması ve bunun dışında da aynı zamanda alınan kararların herhangi bir şekilde uygulanıp uygulanmadığının, herhangi bir kontrolünün yapılamadığından dolayı hem devletlerin alınan kararları herhangi bir şekilde kafalarına çok takmadan yapmalarına hala devam etmeleri, hala o ihlallerine devam etmeleri, aynı zamanda bunun yarattığı sonuç olarak da bu ihlallerin hiçbir şekilde durmaması, aynı zamanda bunun sivil society olarak sivil kuruluşların bu sistemin geneline olan inancının azaltması gibi şeyler söyledi. Ama sistemin şu ana kadar kazandığımız şeyler açısından da insan hakları ihlallerine olan mücadelemizde en büyük gelişme gerçekten geçmişe göre çok daha bilinçli bir sivil topluma sahibiz ve sistemin nasıl işlediğini çok daha iyi biliyoruz. Eskiden sistemin içindekiler dahi bunun nasıl işlediğini bilmezken şu an herkes çok daha işin nasıl işlediğini bilip daha iyi sorumluluklar alıp daha iyi değerlendirmelerde bulunabiliyor. Özellikle özel raportörlerin raporları gerçekten gerçeği yansıtıyor ve bu insan haklarına mücadelede çok büyük bir rol oynuyor. Thank you very much. It was just...
Thank you for your translation.
Now, I give the floor to Mehmet Kilic, president of the Journalists and Writers Foundation. And I understand that Mehmet can give us some concrete examples concerning the persecution of the Gulen Movement in Morocco, in Pakistan, in some other countries, and to what extent these cases have been submitted to the mechanisms that we've already been discussing, and with what success. Mehmet?
Good morning, good afternoon, and good evening to you all from New York, wherever you're joining us. First of all, I'd like to thank the International Association for Human Rights Advocacy in Geneva for inviting me to this important panel, and I would like to share our experiences and perspectives on the UN treaty bodies and special procedures with limitations and achievements in the fight against human rights violations in Turkey. Of course, Turkey has gone through unprecedented human rights violations under Erdogan's rule after the attempted coup of July 15, 2016. The erosion of democratic values, the collapse of the rule of law, and serious human rights violations in Turkey, as well as abroad by the government of Turkey, may now amount to crimes against humanity, as repeatedly confirmed recently in the decisions by organs of the UN treaty system, in particular the Working Group on Arbitrary Detention and the Working Group on Enforced and Involuntary Disappearances. The ongoing human rights violations by the government of Turkey have now turned the country into an open-air prison for hundreds of thousands of people, even if not formally deprived of their liberty. Being denied any future in the country and facing arbitrary detention, lack of fair trial, discrimination and persecution, an increasing number of civil servants, including teachers, professors, lawyers, journalists, judges, police, military personnel, or other professionals at risk, are trying to leave the country and ask for international protection. Not only in Turkey, but abroad, Turkish teachers, businessmen, academics, and other intellectuals are under increasing distress and face enforced and involuntary disappearance, attempts to forcibly and illegally transfer them to Turkey, where they would be subject to arbitrary detention, torture, and ill treatment. They face abuse, inhuman and degrading treatment, precarious living, health, financial, economic conditions, and have their passports canceled, their children born stateless, and many face arbitrary deprivation of nationality. Now, let me turn to our topic of today's discussion. First, I would like to talk on the limitations, Then I will talk about the achievements of the treaty bodies and special procedures as regards to Turkey. I will try to be brief in my remarks in order to streamline our discussion during the Q&A session. But before my explanation, I would like to explain my understanding on the limitations of the UN human rights system in terms of procedures of the international investigation or settlement. I will have to go back in time to a particular date. And you may remember September 6, 2016. This is just 15 days after the attempted coup. On September 6, 2016, in the middle of horrific human rights violations, including widespread and systematic torture in Turkey, the Foreign Minister of Turkey paid a visit to the Council of Europe. Following the visit, the former Secretary General of the Council of Europe, Mr. Jagland, had a press conference with the Turkish minister and then President of the Council of Europe. In his statement, the former Secretary General of the Council of Europe said, and I quote, "It is important for us and for Turkey to work with us to prevent that a flow of applications from Turkey land in the European Court of Human Rights." Mm-hmm. And also he added, "A large delegation from the Ministry of Justice of Turkey visited us to discuss at the expert level the compatibility of decree laws with the requirements of the European Convention on Human Rights. We want to see that the judicial safeguards are in place. If they are not in place, many of these cases will land in the European Court in Strasbourg." So it shows that there is an agreement, an elegant way out for the government of Turkey, the Council of Europe, and the European Court of Human Rights to deny the increasing number of petitions before the European Court of Human Rights. Then what happened? On January 23, 2017, the government of Turkey established a state of emergency inquiry commission. The commission was meant to be an effective remedy for thousands of dismissed public officials. However, it was designed to be an obstacle, a tool that an elegant way for the government of Turkey, the Council of Europe, and the European Court of Human Rights to deny petitions by hundreds of thousands of victims. Then what happened? Thousands of petitions filed with the European Court of Human Rights by the victims in Turkey were denied, and unfortunately, people lost their trust in the European Court. Mm-hmm. Now you may ask why I brought this issue of the European Court of Human Rights here. Well, the European Court had taken landmark decisions on human rights violations, and its rulings are binding in Turkey. But now the European Court of Human Rights rejects the petitions from Turkey, and the judicial system in Turkey is broken since 2016. So the only viable organ of the international investigation or settlement for victims in Turkey are the UN treaty bodies and special procedures, of course, with their limitations. Now, if you allow me, I would like to talk about some of the limitations of the UN treaty bodies and the special procedures. I would like to give 5 limitations from the perspective of Turkey. The UN treaty bodies and special procedures cannot consider hundreds of thousands of petitions for relief from Turkish nationals. There is a big discrepancy between the need and the system's ability to respond. Right. This is mainly because of the lack of financial and human resources. You can try to have as much as possible joint submissions and also distribute as much as possible the workload throughout the system, but it is not easy. We've seen it in the case of Kosovo and other cases. You can also try to use other mass mechanisms of relief, such as the inquiry procedures, which you already mentioned, the shadow and alternative reports, or follow-up reports, again mentioned by the speakers before me. But they cannot change much in the situation of the specific victims. They can only help to solve systematic and widespread violations. Further, not all UN member states are parties to relevant international human rights instruments. Considering the abductions or disappearances in different countries, so it's not only Turkey, but it's the other collaborating country. In addition, not all state parties have accepted individual communications procedures, as you know. Therefore, the last resort for legal ground in some cases has been the Universal Declaration of Human Rights. In the case of the UN member states against which a petition is not possible, that country can always be bound by the Universal Declaration of Human Rights before the Working Group on Arbitrary Detention. And yes, there are some limitations, but you can always try to overcome them. I think the biggest limitation, however, without a doubt, is the implementation of the decisions and opinions by member states. And in our case, mostly the government of Turkey. Let me be clear, there are no easy shortcuts here. There should be always a broader and consistent effort by all relevant stakeholders to ensure implementation, or at least partial implementation. Special procedures do not have additional enforcement mechanisms to ensure a remedy for all recommendations rather than partial implementation. Lastly, last but not least, of course, the COVID-19 pandemic presents another limitation, but I would not want to go into details with that. In terms of the achievements, I would like to mention a few achievements. In many cases, governments do not implement the UN treaty bodies or special procedures, including Turkey, because they are considered non-binding rules, unlike the European Court of Human Rights decisions, for instance. You also have cases the other way around. Victims who have obtained interim relief by the committee and also resettled in a different country do not accept requests and recommendations to withdraw petitions with the idea that it may be available for some space for other victims of human rights violations. Governments periodically renew their commitment to support the UN treaty bodies and special procedures, including Turkey, and duly implement their decisions. However, they should also promptly implement the decisions by the treaty bodies and special procedures. This is not the case for Turkey, unfortunately. I mean, they renew their commitment, but they do not respect the decisions of the treaty bodies and special procedures. Until recently, I used to think that it is an achievement if these two elements were present. Number one, if we had a favorable decision by the treaty bodies or special procedures, and number two, if there was some sort of relief, at least the release of the victim partially, not as a whole. I don't want you to take me wrong, but I've always had in mind in the interest of the victims first and foremost, but now I think differently. And I think an achievement is also a situation when we only have a decision, but not yet practical relief of the victims. What I mean by this, the victims, mostly members of the Hizmet movement, are law-abiding citizens. Most of them are religious people. They are not criminals. They are, the average victim has at least a master's degree. Yet they are accused of being a member of an armed terrorist organization for having a bank account at Bankasya or subscribing to a Zaman Daily, the largest circulation newspaper. Favorable decisions by the treaty bodies and special procedures and even allegation letter regarding the plight is psychologically and morally relieving. And we've witnessed this with many victims. It is a strong confirmation for the victims and the family members that they are innocent and that they deserve relief. And I would like to finish now where I began. I hope and I believe together we can do more to implement the decisions and provide relief for the victims. Maybe Alfred, during the Q&A session, the first segment, I'll give a couple of examples for achievements and limitations from Turkey. I thank you.
Thank you very much. Let me make one point only: enforcement. Everybody wants to see enforcement, not only to get the satisfaction, but in order to justify the system, to make the system meaningful. Therefore, in the European system, you have the Committee of Ministers of the Council of Europe. And when in the years 1996 and 1998, the European Court of Human Rights in the case Loizidu against Turkey, found against Turkey. What did Turkey do? Ignored it. The Committee of Ministers was very patient, issued the first resolution reminding Turkey, our decisions are binding. That was in 1999. Nothing happened. A second resolution was adopted by the Council of Ministers in 2001. No reaction. In 2003, Committee of Ministers issued such a tough resolution that essentially was either you implement or you're out, because you cannot be a member of the Council of Europe. You cannot be a member having ratified the European Convention of Human Rights if you do not implement the decisions of the court. And lo and behold, on the 3rd of December 2003, Turkey paid. But of course, it took 3 resolutions to get there. On the other hand, what you said is very true. I experienced that myself as chief of petitions. Even if the victim does not get a cent in compensation, the fact that the victim has been heard, the fact that the victim has been taken seriously, the fact that a body of experts has said, you're right. I mean, you are a victim of violations of your fundamental rights. That in itself is an enormous, shall we say, balsam for people who have suffered. So this recognition of their status as victims is super important. And again, it's a step in the right direction. And now it is my pleasure to give the floor to my former colleague as special procedures mandate holder, Setondi Roland Ajovi.
Just before we start, can I just make a brief explanation in Turkish, just 20 seconds? What was told by Mehmet Kılıç? Sorry, Mr. Roland. Mehmet Bey az önce şunlardan bahsetti. Öncelikle Avrupa mekanizmaları önünde bizim maalesef herhangi bir şansımızın kalmadığını, gerçekten Birleşmiş Milletler mekanizmalarının bizim için tek yol olduğunu öncelikle söyledi. Bundan sonra kendine göre gördüğü büyük zorluklar ve büyük başarıları anlattı. Büyük zorluk olarak gördüğü şey, gerçekten çok fazla büyük başvurular yapıyoruz. Çok fazla kişi olarak BM'nin şu anki kaynaklarıyla bunu bakabilecek durumda olmadığını söyledi. İkinci olarak da en büyük sorun olarak yine uygulamaya geçirmenin Birleşmiş Milletler tarafından alınan şeylerin çok zor olduğundan bahsetti. Büyük fayda olarak ise genel olarak söylediği şey ülkelerin de hükümetlerin kendi bu Birleşmiş Milletler mekanizmalarına olan güvenlerini devamlı olarak her yıl tazelediklerini, dışarıdan Birleşmiş Milletler'e ve uluslararası hukuka uyan bir devlet olarak görünmeye çalıştıklarını, bunun büyük bir başarı olduğunu en azından söyledi. Thank you very much, Mr. Alfred Zayas.
Splendid. Thank you. And now over to Mr. Ajovi.
Thank you very much. I'm happy I have been invited onto this panel. What I want to talk about, and I will try to make it as concise as it could stay within the 10 minutes, it's what has been the operation of the working group over the last few years, especially since the attempted coup in 2016. That attempted coup, the consequence, we all know them, but it's wrong to think that the violation we are facing are specific to the attempted coup. I want to submit to you that Turkey has not changed. Maybe things increased, things got worse, but what we are seeing, there is a pattern which was already in place before. The working group was there, and I'm going to base myself exclusively on the working group, if you allowed me. The working group visited Turkey in October 2006. And if you look at the reports, the recommendation, they had positive assessment of some aspects, but the challenge, the criminal justice system, the penitentiary, the long pre-trial detention, the abuse in the detention places, some broad law which allowed to lock anyone, a kind of political opposition, into jail. What are we seeing afterward? After the attempted coup, I have done a countdown. In 2016, we didn't have any opinion related to it. But in 2017, we had 3 opinions. In 18, we had 6 opinions. In 2019, we had 3 opinions. In 2020, we had 6 opinions up to 31st August 2020. Think about this. The working group issue about 60 to 90 opinions a year. It means we have issued some years recently about 10% of our opinions about Turkey. Out of 190 states, we have jurisdiction over. And what are we having in this opinion? The opinion I have listed, only one is about a foreigner, an American pastor. But it's relevant because you have Turkey using imprisonment criminal justice as a tool against other states to bargain. Yeah. In this case, we had an American citizen. It's also a tool against religious minority in the country. This is a Christian pastor who is being imprisoned. And it was obvious that those 2 elements, the fact that he was American and the fact that he was Christian, matters. As far as the Ismet group is concerned, we have an abuse against a religious group, but we have an abuse against political opposition. That's what it is. Because these people used to work together. I'm not Turkish, I'm not expert in Turkish politics. But what I read is that the Fethullah, the Ismet movement supported the AKP before. And they had a breakdown in the relationship in late 2010. And this led to blaming them for everything after the attempted coup. Yeah. And in this strategy, discriminatory, you have then anyone from far, from close, connected to the group being locked up. This group had bank account, had school, had given scholarship. Cases we had are teachers, professors at the university who had received funds, who have bank account, who have received scholarship from the group. How is it criminal to receive scholarship to study? How is it criminal to go to a certain university? How is it criminal to be part of a group? As far as it's not a criminal group, a terrorist group, and when I say terrorist, I'm not using the word as the state are using them. I'm using terrorists as people who use terror to terrorize the population. True meaning. And we have people using by-lock application being criminalized. How using an application could be criminal? I use Telegram, I use Signal to communicate with victims around the world to get confidential information about the states. If it's criminal, I'm sorry. I want to be in jail next to those people. So in the working group, that's what we have seen throughout the cases. And it reflects in the category of arbitrary detention we have. You have in almost every case a category 1. Lack of legal basis for the arrest and the detention. And often the broad definition of the crime, of the offense they are using against these people. Using by-lock application is not a terrorist participation. It's not a terrorist act I'm sorry. No matter how you turn around it, it has nothing criminal. Going to a school set up by a certain group is not criminal. And you can hold people accountable for that. So category 1, we have category 3 in almost every cases. Category 3, remember, it's fair trial. This is something we have already challenged in Turkey in 2006 report, saying we are not seeing fair trial granted to these people. They are being detained for long. People are detained for 10 years. Pre-trial, I'm sorry, it's wrong. And then we have the core elements, category 2 in some cases, and category 5. A category 2, all these journalists being locked up because they might have financial connection to the ISMET group. How is it criminal? And all these journalists being closed, being disbarred kind of, that's what we are seeing. And these people are being targeted for who they are, what they do, the freedom they are enjoying. The working group say category 2. And then category 5, because anyone with connection to the ISMET group is being discriminated against. So if you go through our case, you will see how throughout the past 4-5 years, we have reflected what we are all talking about in Turkey through our opinion to show that first, Turkey has not changed. The violation we had before are still there. Things are increasing. Things are getting worse because so many people have been locked up after their attempted coup. Overly broad criminal definition or criminal offenses, it's still there. And they are using the terrorism as a framework. And I'm sorry, so many other states are using it as well. But it doesn't make it better. It makes it wrong for Turkey. It makes it wrong for everyone else. Then we have the fair trial in the process, which remain a pattern before the attempted coup, which is still present after the attempted coup. The discrimination. Previously, we have discrimination against the Kurds, and it's still there. It has not disappeared. Now we have discrimination against a new group, the ISMET group. And that's what we are seeing. Now, some of the issues raised earlier, I want to touch them very quickly and I'll stop there. How effective are we? I'm sorry, we are as effective as the state wants us to be. And as we stand, states are not interested in us delivering anything beyond their opinion. Full stop. In my view, the victim are getting satisfaction being recognized as a victim, but they have to do something essential, which I'm not seeing enough worldwide. Use the opinion and go back to your judge, force your domestic judge, your regional judge to take the next step after the opinion. We don't have an enforcement mechanism for the special procedure. It doesn't mean the special procedure are useless. The working group is unique because it has a litigation procedure. You get that opinion, take it to the next step. Yeah. Go back to the domestic judge, say, Judge, I have been recognized as a victim. What do you want to give me? The judge will say, we don't recognize the opinion of the working group, and you'll get another level of conversation. They discuss about whether the opinion of the working group are binding or not. I have made my view clear while I was in the working group, and I'm still stand by it. If you set up a dispute settlement process and you say the outcome is not binding, I'm sorry. As a litigant, I'm not going to use the procedure. Full stop. What is the point of creating a dispute resolution mechanism when you say the outcome is not binding? And remember, and you mentioned it earlier, is it only about the working group? The European Court who dispute the bindingness of the opinion of the European Court. The European Court issue opinion. who is complying with it? It takes time, it takes political pressure. So the working group is nothing different. Don't tell me the opinions are not binding. The opinions are what they are. Let's use them and make the best out of it and enforce them. I'll talk about Africa. I'm from Benin. I'm currently in Benin. The African Court issue opinion about Benin. The government doesn't care. Is it because the opinion of the African Court are not binding? No, it's because we are in the political arena, in the international political arena, and that's how states are functioning throughout. And when I say state, it's some of us working on behalf of the state. That's the bottom line. So the opinions of the working group, whether they are binding or not, do not stop there. Use it, go to litigate wherever you can use them, do the usual political advocacy you do with them to get enough pressure on the state. At some point, we might get some positive result, and I'll stop there. Thank you very much.
Thank you. Thank you very much, and bravo. I mean, you've been crystal clear and very important to indicate that and to understand that the problems in Turkey did not begin in 2016. There was a consistent pattern of gross and reliably attested violations before 2016. And very, very happy that you stressed the importance of the existence of this system of dispute settlement and what it actually implies. We should not give up on the system. We should use it more, not less. And now you're going to give us a little summary. Are you doing?
Thank you very much. I will just summarize. Rohan Bey'in söyledikleri şeyler gerçekten çok kritik şeylerdi. Şu açıdan öncelikle 2016 öncesinde de Türkiye'de çok büyük ihlallerin zaten yaşandığını, sonrasında bunun gitgide arttığını, eskiden ayrımcılık yapılan grup olarak Kürtlerin olup daha sonrasında 2016'dan sonra buna yeni bir süje olarak hizmet hareketi grubunun eklenmesini ve inanılmaz büyük bir adil yargılanma hakkının ihlal edildiğinden dolayı inanılmaz büyük önlerine davalar geldiğini, Working Group on Arbitrary Detention, yani keyfi tutukluları inceleme çalışma grubu önüne geldiğini, bunun aynı zamanda her zaman en çok karşılaştıkları şeyin hiçbir zaman bir hukuki bazı olmadan gelen büyük tutuklamalar, uzun yıllarca süren 10 yıl boyunca hiçbir sebebi olmayan tutuklamaların olduğunu Türkiye'de, baylok gibi şeylerin asla ve asla suç sayılamayacağını, okula gitmenin, bir yere üye olmanın, bir gazeteye abone olmanın asla suç olarak değerlendirilemeyeceğini ama insanların bundan dolayı uzun uzun tutukluda kaldıklarını çok güzel açıkladı kendisi. Ama yine en büyük sonuçla geldiği noktada hiçbir bağlayıcılığı olmayan mekanizmaların neden var olduğunu sorguladı. Bunu göz önüne serdi. Bunların aslında devletlerin kesinlikle uygulaması gereken görüşler olduğunu, aslında hiçbir mekanizmanın durduk yere bağlayıcı olmadan kurulmaması gerektiğini, bunun da mantıksız olduğunu, o yüzden zaten bunların hepsinin bağlayıcı gibi görülmesi gerektiğini bahsetti. Thank you very much.
Thank you. Now we have a Q&A from the moderator, but since I've been making so many comments, I want to keep this very short. I have a question to all three participants. How can we make the mainstream media take the United Nations treaty bodies seriously and take the United Nations special procedures seriously? How can we get more visibility in the mainstream media? And as to what I already mentioned before, Mehmet Klinç, I wanted to know a bit more on the situation of the Gulen schools in Pakistan and Morocco. Thank you.
Well, thank you so much for this question. I think one of the ways that we can have these UN treaty bodies and special procedures decisions to be to appear in the mainstream media is the civil society organizations and people. We have to, raise our voices. We have to, take action to to follow up with the decisions of the special procedures and make it a campaign. For example, recently, it was about like 2 weeks ago, the Working Group on Arbitrary Detention made a decision on the case of Kosovo, where 6 Turkish nationals were illegally abducted and transferred to Turkey. So this decision is published on the website of the special procedures. But if the civil society organizations and individuals, if we do not, bring this up, make press releases, send it to different media outlets, make a social media campaign, and raise our voices about this opinion, so they're not going to be able to see it. So I think there are shared responsibilities for all of us as, civil society, media, human rights defenders, experts. So it all falls on our shoulders, I guess.
Thank you. Were you going to say something about Pakistan and Morocco?
Yes. Well, if you allow me, I would like to share 2 cases which is unique. And one is from Pakistan. So on September 26, 2017, the Pakistani law enforcement agencies abducted Mr. and Mrs. Kachmas and their 2 young daughters from their apartment in Lahore. So these, Mr. and Mr. Kachmas, they were teachers at Pak Turk schools affiliated with the Hizmet movement, and they were held incommunicado for 3 weeks in Pakistan. Then they were transferred to Turkey. So when we, look at these—
How were they spirited out of Pakistan? Because if you leave a country, and a country like Pakistan, I would imagine that there must be some papers. If you go to the airport, you would have had the opportunity to protest if you're being kidnapped.
Well, actually, there are so many different violations, even domestic violations, because his lawyer, their lawyer in Pakistan, they went to the court, and the court decided no exit decision, that not so that these people should not leave the country before the domestic court makes a decision. But however, internally, the Turkish government's agents working with some agents from the government of Pakistan, they get them through an airplane with no tail, sign. This was an illegal transfer. I call it illegal and clandestine transfer of the victims from Pakistan to Turkey. Yeah. So it was a violation of abduction, enforced disappearance, arbitrary deprivation of liberty, and
Pakistani law.
Yeah, all of them. These are grave human rights violations, and against a social group in Turkey. And the only reason why these teachers, not only teachers but the daughters, like young people, which go into the Convention on the Rights of the Child, so they were arrested. They faced all these violations because they are a member of the Hizmet movement. And the fact is that these people were not in Turkey at the time of the failed coup. So what happened then, the Working Group on Arbitrary Detention made a decision on May 25th, 2018. And then it was a good achievement for the relief that the Turkish court decided to release Mr. and Mrs. Kachmas after 8 months of imprisonment. Well, this was, I think, a great achievement. But however, these, the 2 teachers, they were given 6 years and 3 months of imprisonment. So it was a partial, achievement, and they were denied to leave the country, which is against the Article 12.2 of the ICCPR, and also the working group made 3 or 4 decisions in the decision. This was immediate release, compensation and reparations, and conducting an investigation. And other than a conditional release, none of the compensation or reparations or conducting an investigation was not respected, neither by Turkey nor by Pakistan. So, this is a partial, we call it partial achievement. And there is another case from Morocco. Since the Turkish government is pressuring different countries, including Morocco, the schools were closed in Morocco. So what happened after then, in 2017, the Turkish government requested extradition of 4 Turkish citizens living in Morocco, and they were under the protection of the United Nations. So they have the UNHCR protection. And then the government claimed that these citizens participated in the attempted coup, even though these people were not in Turkey at the time. So some of the accusations, just as Mr. Roland mentioned, it is mind-blowing. So working as a professor in a school affiliated with Hizmet Movement, having a bank account, making a donation to a charity organization named Kimse Yok Mu, subscription to a daily newspaper, Zaman, or being a member of an international commerce organization named TUSCON, or just giving scholarship to poor students. So these are considered as terrorist activity, which is not accepted by any of the UN treaty bodies or any member states, I would say. So what happened after this extradition case was submitted to the government of Morocco, and since in 2002, the Morocco and government, Turkish government had an agreement of extradition of criminals. But since this is a political crime, it does not constitute an extradition. Okay. Yeah. So the Supreme Court, despite the fact that this is not this is a political crime, they gave a favorable opinion for extradition of these 4 individuals to Turkey. Then what happened? The lawyers of the victims, they submitted a petition to the UN Committee Against Torture, so that the Kingdom of Morocco does not extradite them to Turkey, and instead, this is for Morocco to uphold its human rights obligations under the relevant international treaties as a state party. So, as an interim measure, the Committee Against Torture asked the government of Morocco not to extradite the individuals at risk, and until the CAT adopted an opinion on the case. So the good news is that the government of Morocco complied with the interim measure, excuse me, froze the extradition case of the Supreme Court and waited for the decision of the Committee Against Torture. And then the committee decided that if they were to be extradited to Turkey, so they would face torture, ill treatment, and so forth. So the government of Morocco did not extradite the victims to Turkey, but rather release them. So I think this is a great achievement of the UN treaty bodies and special procedures in delivering justice and relief to the victims and their families. So these 2 cases, I think, gives hope to us that even though there are challenges, the UN treaty bodies and special procedures, we have to follow up, their opinions and push more, support them as civil society organizations to give relief to the victims. I think this is the only way we can do.
Thank you, Mr. Kilic. That is very important. You know it, I know it, but the mainstream media does not make it visible. And potential victims do not know that it is, in some cases, quite effective to invoke the procedure of the Committee Against Torture and to demand interim measures of protection and to demand an injunction that then the state would observe. So any comments from Eric, or any comments from Mr. Ajovi before we move on to questions and answers from the audience?
I would like to make a few comments if you allowed me.
Please.
So on the mainstream media, I'll give an example from the working group. We had lengthy discussion about communicating on our opinions. Not everyone was of the same view. We did one experiment, and I will explain about Julian Assange. Yeah. When we were issuing that opinion, we were of the view that this was critical and we need to communicate. We agree. I was the spokesperson of the working group. I gave that day, within 24 hours, I gave almost 100 interviews on the phone. it's unmanageable.
Yeah.
The public relation of the university was on my side to help me throughout, taking the phone call. I was in class, TV came on the campus to record me. It was a nightmare, but we did it. And we know how useful it has been to provide a counter narrative to what the government of the UK was doing about the opinion. We want to publish about every opinion. We don't have time, we don't have the resources. So from time to time, we issue a press release about certain opinion if we think it's critical and that is necessary and the source requires it. I have personally tweeted all our opinion over the last 2 years because I thought that it was important to put them in the public domain. But not all my colleagues were happy about me tweeting their opinions. So from an institutional perspective, there are difficulty with communicating in the press, there are capability issue, there are resource issue. So you have to bear that in mind because the mainstream media need to be told what the story is. Otherwise, they don't get it. Yeah. As far as the other states are concerned, yes, you are right. In the opinions, we had 4 states who have been connected to the Turkish case. We have Pakistan, as you mentioned rightly. We have Azerbaijan, we have Kosovo, and we have Malaysia, where we have cases of Turkish national who Turkey managed to get extradited, not in a clean manner. And the working group hold both states accountable, hold violation against both states. Now, there is one element which is interesting about Azerbaijan. There is an opinion in Azerbaijan, and you'll see how Turkey is getting payback. Turkey arrested an Azerbaijani political opponent who was a refugee in Germany, went to Turkey on a visit and was arrested by the Turkish authority and extradited to Azerbaijan and going to jail. And the working group was astonished because this is a refugee. He has a political asylum protection, and Turkey arrests him and sent him to Azerbaijan instead of sending him to Germany, where he had full paper and documentation. And we made it clear in the opinion, this was a violation of the refugee right, and that Germany has a right to hold Turkey accountable for the violation of the protection they grant to that individual. So yes, you have this strategy of Turkey going around fishing for those nationals who are connected to the movement, but it's because other states are seeing their interests being served. And in the case of Azerbaijan, we have a return of the favor where Turkey arrested one of its political opponents and transferred him to Azerbaijan. Thank you.
Thanks again. Eric? Unmute yourself.
Sorry. Now, I said on this question, I think everything has been said. I think it's better to continue with the questions.
Shall we open now for questions and answers from the audience? Mm-hmm. By the way, I noticed that it is 4:26. If we were going to stick to the hour, we will only have 4 minutes. I suppose we can extend it, but I don't know how much we can extend it.
Alfred, do you mind if I add to what Mr. Roland said about?
Go ahead.
I think, Mr. Roland is very right about how, the government of Turkey is negotiating with other countries in terms of exchanging dissidents. I would like to give another example how the government of Turkey is pressuring countries like Macedonia, let's say North Macedonia. So as you know, North Macedonia is trying to become a member of the NATO. And when the defense minister of Turkey visited Macedonia, and then he put on the table, they said, if you close these Hizmet affiliated schools and hand over these teachers back to Turkey, then we will support your NATO membership. So as you can see, it's not only extraditions, abductions, but using all economic, political, military means of the country to oppress the dissidents outside of Turkey, and I think this is not acceptable. So in such cases, when like countries like Macedonia, Kosovo, or Bosnia-Herzegovina, let's say, when they are under pressure by the government of Turkey because of economic, political, or military, relations, I think the European Union and countries like Germany, France, US should intervene and should remind those countries about their commitment to human rights, democracy, and rule of law. Otherwise, if there's no counterbalance, those countries would give in the pressure by the government of Turkey.
In other words, European countries are complicit in the violations by Turkey, to the extent that the European Union, to the extent that the countries of the Council of Europe tolerate all of these violations of human rights, they are complicit. To the extent that they continue selling arms to Turkey, to the extent that French businesses and German businesses and UK businesses continue selling and buying from Turkey, they are complicit in maintaining this kind of dystopia in place. So, having said that, how much time do we have? Because I see now it's 4:30.
There is a question posed by a participant that I'm now showing to you. The question is about, is there any other mechanism as International Criminal Court?
Well, let me take that myself. Turkey is not a state party to the Statute of Rome, but the International Criminal Court can open investigations about a situation, because if there are violations of the Statute of Rome by Turkey, that very frequently involves other states, and other states are states parties to the Statute of Rome. So it is possible to begin an investigation. It is difficult to bring, say, a Turkish national before the ICC, but at least it is worth trying. I mean, the policy of naming and shaming does have some validity, to the extent that countries are concerned about their image. And if you are being investigated by the ICC, it hurts. It's like the United States, or rather Donald Trump, overreacting to the investigation of Fatou Bensouda in the case of Afghanistan and Iraq. Obviously, the crimes were committed by US soldiers, by NATO soldiers, etc. And that just splashes badly on the reputation of the United States. So the United States doesn't like it. Turkey wouldn't like it either. But an investigation by the ICC certainly would be recommendable. Eric or Mehmet or any other comments, Ajovi, on that point?
Nothing from my end. I fully agree with you.
Mm-hmm. No, again, naming and shaming, I'm not always an advocate of naming and shaming. I'm very much an advocate of trying to persuade governments that it's in their own interest to change their methods. it's in their own interest and in the interest of their populations to observe their international obligations, international human rights treaties. On the other hand, sometimes the embarrassment that can ensue from a publication in the New York Times, in the Washington Post, by CNN, by the Frankfurter Allgemeine Zeitung, that might persuade a country that maybe some adjustments are necessary. Other questions?
There's one question, just following the other one I'm just showing you now. I will just show it to you. Our participant who just posed the question says his question was misunderstood, and he wanted to underline that there's a member judge of ICTR who is arrested in Turkey, a former, and the UN has not offered the state to release him. So what and how can we expect from UN?
Well, I mean, don't give up. And the question is, who is going to trigger the action? Obviously, it would be a matter of solidarity of the system of the United Nations to protect its own. But I mean, all of us rapporteurs, I would not be surprised if Mr. Adjobi also suffered personal invectives and insults and threats. I had threats in my 6 years as independent expert. And I must say there's no mechanism in the system that will automatically protect you. But the situation is so outrageous that you would expect, say, the Secretary General of the United Nations to take it up. And the good offices of the Secretary General, the good offices of the High Commissioner for Human Rights directly with Erdogan. This is something that is overdue if it hasn't happened. I am not aware, but it may very well be that behind closed doors, I mean, that without any fanfare about it, that some negotiations are in place to obtain his release. By the way, for 7 years, I was president of the PEN International Centre Suisse Romand, so the Association of Writers. And we issued a tremendous number of resolutions concerning imprisoned authors and imprisoned journalists in Turkey, and way before the so-called coup of 2016. In some cases, with success, we managed to get some people released. But there again, notwithstanding all of our resolutions that are public, that are in the internet, you don't see them cited in the New York Times or in the Washington Post. It's sometimes you think you're writing just for yourselves. You're writing, you know, for your own audience, but it just doesn't make it out there. So one of the main problems, I think, in addressing the violations of human rights in Turkey is the fact that they're not sufficiently well known. I mean, I would say, you know, Turkey is, for me, a notorious rogue state. But so is Saudi Arabia. And the Europeans continue doing enormous business with Saudi Arabia. So here, the relationship between business and human rights is an important one. And I dislike hearing so many European leaders invoking human rights and invoking European values. Well, I would like to see them implement them. I would like to see them calling Turkey to account, calling Saudi Arabia to account, etc. But that is not happening. And my only explanation is that money speaks louder. Other comments, or do you want to do some summary for the audience?
If I could add something to that answer.
Please do, please do.
So about the judge from the tribunal who was arrested and who might still be in detention, I don't know. This is lack of information when one say the UN did nothing. The tribunal has issued several communications to the government and said this is unacceptable. The UN has done the same, diplomatically communicate to the government that this is wrong. So many governments have put pressure on Turkey to release him, to stop the proceedings against him. And if you search about the statement by the president of the tribunal, you'll see them. I want to mention one case, which was not Turkey. It's a case about Tunisia, where the investigator of the Security Council, of the investigation panel of the Security Council, was arrested for what he has been finding about violation of the embargo on Libya. Mm-hmm. The working group issued a very strong opinion in July 2020, opinion 26, mm-hmm. where we describe how outrageous it is, the violation of the immunity of that person. So, Alfred, I agree that we are not protected. There are laws to protect us. They are not always enforced. But in this case, the working group used its mandate to say it's unacceptable. If the UN deploy us on the ground to help and you arrest us, you violate the immunity granted to us, it's outrageous. So in that case, the working group gave an example of how we could use the existing law to state the protection those people have. It doesn't apply to the judge as such because he was in his own country accused of other things, but the UN did put pressure on the government to say release him. Mm-hmm. Thank you.
Yeah, thank you very much. Now, are there any additional questions from the audience?
There's one question. I'm just reading it. What do you think about recent attempts from some countries to limit and control special procedures independency? It's now the case with Mrs. Kalamar's position on Mr. Khashoggi assassination. What do you think about recent attempts from some countries to limit and control special procedures independency? Yes.
Well,
by Mr. Ricardo.
My colleague Jovi can say something about it too, but obviously countries for a very long time have tried to cut our wings. You know, they're trying to discredit us, to insult us, to take away from our credibility. I remember my friend Van Hili, when she was the rapporteur for Myanmar, how she was defamed by Myanmar, how she was defamed by any number of proxies of Myanmar. But being defamed actually is part of the job. I mean, I knew when I was named independent expert that I would be attacked, and I did not let myself be intimidated. I was always, I always spoke my mind, even if I was wrong, but I spoke my mind. And sometimes that has consequences. For me, it really didn't have any consequences other than having to accept some very heavy insults. But I would imagine that some rapporteurs do get intimidated. I mean, it's not just offending your honor and your reputation, but it's also the danger of being detained, the danger of being ill-treated, the danger of being killed. So, I mean, that does exist. Now, any comments to that, Mr. Ajobi?
So it's states created the mechanism, the procedure, and states are always trying to control how much they are doing, and the tension will increase anytime states feel frustrated. Yeah. When we issued the opinion about Julian Assange, we were threatened. We were threatened from all over the place. Our email accounts were hacked, not by the Chinese, not by the Russian, by the Western countries. I'm sorry. I was told that the mandate will not be renewed. I told one ambassador in Geneva, my friend, I have a daily job where I'm paid. This job, I'm not paid. You do you, I do me. Move on. There is nothing to talk about. We have no conversation. I'm sorry. I'm not there to please the state. I'm not there to please anyone. I'm there to deliver based on my mandate and based on my ethical value, my moral value, and I do it independently. So that pressure, that tension remain constantly in the process, and there is nothing wrong about it. We hope that we will every time get enough support to counter any attempt to limit or to control the mechanism. Sometimes
I'm supposed to inform the Office of the High Commissioner for Human Rights of these absolutely unacceptable pressures.
And what do? They do nothing. We asked them to set up email accounts for us. They were unable to do it for 5 years. My university has to protect my account specifically. So even if you report it, what are they going to do? They are as scared as you are, and they are even more exposed to the state influence because they have the career to save. I'm not a UN staff. I don't give a damn what they do about me. I have my name and I protect myself. So even if you report, it's good to report so we have a record of what is going on, but don't expect so much about it. Expect that some other state will support you and that you'll get enough consensus around your mandate to move on. Otherwise, the overall plan is jeopardized. Thank you.
Thanks a lot. Eric, yes.
Yeah. I think on this point, we have to make, from my point of view, a distinction between the pressure that we cannot avoid, states will try to pressure, from something which is, for me, more problematic. It's an attempt to attack the credibility of the report. You know, officially, those reporters or the mechanism are people who have been selected because of their impartiality, etc., you know. But at the moment they present the report, some of them are attacked on the fact that the work has not been done correctly. And that is weakening.
Yeah, of course.
Is weakening the message, you know. So I can understand that the state is not happy and try to criticize you on, I would say, a personal basis or on your opinion, etc. But the report you are presenting, if they have criticism to do, I think they have to be much more substantiated, you know. It's like your current president pretending they are fraud. No. That should not be protected. It's not because he has an immunity that he can lie on a situation like that. And I was shocked to realize that, for instance, Pinheiro, when he presented, or other people who were presenting reports on a situation, I remember the one on Burundi. I remember where the attack was on the fact that the report is not accurate. And here I think the UN has to react and said to this criticism, either you are coming with clear proof of failure in the method, etc., or you have to apologize. You cannot decriminalize a report which is now a document that should go. Because at the end, it ends up by a type of game where you have Cuba, and with the UPR, it's getting even worse, you know.
Yeah.
And I think it's also part, I guess, of the problem we have with the press. I remember many years ago when I was, for the first time, attending meetings at the UN in the 70s.
You're right back.
The presentation by an organization, the presentation by a reporter will be taken seriously, in the sense that there were critics, they could have different opinion, but not this type of delegitimation, attacking the legitimacy of the presentation. And here, I'm afraid that the UN should find a way to stop that, and not to accept that states are coming with fake news on the presentation and pretending. I heard even delegation pretending that the reporter has not visited the place or has not really accurately presented the situation. They should be, in this case, it's attacking the substance of the report. There should be some procedure to ask such attack to be scrutinized, and a warning to the presentation to the woman who is attacking in this way the rapporteur or other institution, you know.
I should add to that, the attack does not come exclusively from states.
No.
The attack can come from proxies of states.
Yes.
As you very well know, there are what is termed gongos, government NGOs. They have consultative status, they have a lot of money, and they have access to the press.
Yeah.
So some NGOs engage specifically in defaming rapporteurs. I will not name the NGO or Gongo, but there's one NGO about whom there is a dossier this big in the office of the High Commissioner for Human Rights with complaints of its misconduct, in which they have defamed Mary Robinson, Louise Arbour, Navi Pillay, rapporteurs John Dugard, Richard Falk, Richard Goldstone, William Shabas, Olivier.
I can imagine.
I think you know which one. Yeah. Myself, of course, etc. Even the angel Virginia Dan was defamed by this NGO. It is an absolute disgrace, but it does happen that sometimes the government doesn't want to get its hands dirty accusing a rapporteur of anything. They use an NGO to do their dirty work. Now, as a rapporteur, I knew the code of conduct of rapporteurs like my vest pocket. And I was always extremely careful, super careful, not to even give the appearance of impropriety, methodological or otherwise, in my case. That did not prevent this NGO from trying to, shall we say, detract from the credibility of my reports. So that's something we have to live with, but I would wish that there would be a mechanism inside the Office of the High Commissioner for Human Rights, and that this mechanism would be sufficiently well financed so that the office could react promptly to reestablish A, the credibility of the system, B, the honor and reputation of the rapporteur who has been accused of God knows how many silly things. So that being said, I would like to ask whether there's any additional questions. I note it is 4:52, so we're over by 22 minutes. And if there are any more questions or any additional comments that Roland wants to make, or Mehmet or Eric.
Alfred, I would like to add, I think we had a similar situation with Turkey. You may remember in 2017, I believe, when the High Commissioner for Human Rights, Mr. Zeid Ra'ad Hussein, when they shared their human rights violations in Turkey, the Turkey report, remember what Erdogan and the Turkish government said. They accused the High Commissioner for collaborating with the terrorists.
Yeah.
Right, to delegitimize. They do it. I mean, they want to delegitimize, the report and the individuals. And I think, like one thing that I would like to add to this, part of the, question is that, I participated a conference at Columbia University a few years ago, and the speaker was from the US Department of State. So he publicly said, if there is a conflict between our interests and our values, the government, with no question, picks the interests.
Yeah.
I think, this is very, it was very, shocking for me because, in the US, in the Western world, we value our values, right? Our democratic values. And I believe the interests and the values should be inseparable and indispensable. So what happens is that, like when the Western states choose interests over values, then you give a space for countries who violate human rights and who fund different UN mechanisms or other mechanisms, and then using, like different funding as a fear of favor. Not only, like all different mechanisms or different countries. So that's why, like what I want to say is that, the countries who upholds human rights, democracy, or the rule of law should not leave space for countries who are violating human rights. And you mentioned some countries are now, are members of the, Human Rights Committee, and, like others. They're trying to, I think one of the questions that is being asked is, like the Turkish government is trying to, since there are so many human rights violations, they're trying to, put some of their diplomats or their, people to these committees, special procedures, to kind of like have some eyes within the system.
Yeah, and they succeeded in replacing the Tunisian Mr. Wani with their former ambassador to Geneva. So we have a Turkish diplomat sitting in the Committee Against Torture.
Yeah.
I mean, it is shocking because that position is supposed to be the position of an independent expert and not of a diplomat with very close relationship to the government. And notwithstanding, he was elected over someone who was an NGO person and who was independent, the Tunisian. So part of the fault or the responsibility or the guilt is that of the states that elected that individual into the Committee Against Torture. And again, it would be ideal if all independent experts of the special procedures mandates and all independent experts of the Human Rights Committee, Committee Against Torture, Committee of the Elimination of Racial Discrimination were independent, but you know and I know that they're not. I mean, there are a certain number of experts who are experts. I'm not disputing the fact that they're experts, but whether they're independent, that is another matter.
Alfred, on that point, it's one the question I didn't have time because I was already too long to present, but I think it's a very key element because the expert you mentioned in the Tunisian expert is one of my friends, And we knew that he was in danger because he has not enough support. Yeah. And the system of election by the state party is normal. We cannot challenge that. But what we can maybe do is to circulate a little bit information about the different candidates and start to make a lobby. We were much more active, I speak as an NGO, we were much more active some decades ago when the first system was built up, you know, to make sure that people were independent, were not, because at this moment, for me, it was very strange to realize that some states pretend that to be independent, you should not have been an NGO leader. Mm-hmm. So they don't want to have experts or special rapporteur, etc. I've been an independent, I've been a former leaders because they said they are not independent. And if we cannot have people from government, why do we are taking people from NGOs, which is absurd because the question of independence is the independence from the states that can be accused. But what has happened with the torture committee for me is not only a shame, but it's a big problem. And it's an element now we have to consider when we are presenting a denunciation, a complaint, a communication. It's which body, if we have the choice between the Committee on Human Rights or the Committee on Torture, to which body we send it, not only for a question of to be sure that it will be dealt with certain professionalism and fair, but also to avoid some possible reprisal on the victim and the family. Because I doubt, frankly, that the confidentiality is respected when the government introduce such a type of independent expert, you know, and that is something also which is destroying the credibility of this type of system, you know. If thanks to some negotiation they can get, so we have to respect geographical repartition, genders balance system, etc., etc. I agree, but some government now have established some strange links in order to make sure who is entering, not creating them a problem, and after compensating at the next election for the group or the people who have supported them. And here, I think if an investigation can be done by independent people, maybe we can push journalists to work on that, saying it's a good subject. Why are you not analyzing the last 10 years of nomination of these so-called independent experts? Like you said, most of them have the qualification, technically speaking, and they are good lawyers or at least good professionals. But in terms of independence, there are very big question mark to address.
Yes. We just lost Roland Setonji. He sent me an email, rather a chat message to the effect that he had to leave, which I very much regret. But in any event, I suppose we're more or less at the end.
Yeah.
And there's not much that I can add. Just ask whether there's any additional question from the audience. And if not, then it is for me once again to thank all the participants, to thank the organization for inviting us, for holding this webinar. Thank Eric Sotas, thank Mehmet Klinic, and thank Setondi Roland for this very interesting exchange. I mean, it's an issue that will be dealt with again and again and again. And the overarching principles that we're dealing with apply not just to Turkey, but apply to Saudi Arabia, apply to the United States, apply to Russia, apply to China. So it's, I think it's a good exercise that we have had, and I look forward to having another one in the future. So thank you again, Eric and Mehmet and Zetonji.
And thank you to you, Alfred, and thank you also for the assistance from Yara.
It was a pleasure for us. Thank you for joining to our webinar. It was a great pleasure for us, and we look forward for another webinar that will enrich again our knowledge, our exchange of views. As a law student, I really tried to benefit from it. Thank you so much.
Is there a link to this? Can it be shown again?
A link, you mean?
This, it's an electronic link to this webinar.
Yes.
Shown to somebody else who was not participating.
Yeah, now we're online on live on YouTube, and this record will be on YouTube again. So I will disseminate this to you. There's many participants who are now watching us on YouTube, so you will have the record on it.
Very good to hear that. Yeah. So, happy holidays to everybody.
Happy holidays to you too.
Holidays, thank you. And I want to thank for your efforts, your commitment to the protection of human rights in Turkey. It is, applaudable. It's, on behalf of the victims and our organization, we thank you for your commitment. And also, I would like to thank the special procedures. I mean, every person who are doing an amazing work. There's a lot of workload on them. And there are so many petitions coming from Turkey. And, but, this is the only way, and it is a shared responsibility for all of us. And so we will continue what we're doing. And if we work all together, I think we can do more. We can achieve more relief to the victims. I thank you.
Thank you to you.
Thanks again.
Thank you very much again.
Goodbye.
Bye-bye.
Corda. Lift your hearts.
Goodbye.